Good afternoon, everyone, and welcome to BioStrategy Partners' September Practical Knowledge Series panel. My name is Michelle Washko, the Program Director for BioStrategy Partners, which is designed to accelerate discoveries and bringing discoveries from the laboratory, from the academic setting, to patients, to the commercial world. We have a great panel for you folks today. We have a panel on Term Sheets 101, which is helping folks, scientists, and maybe first-time entrepreneurs understand what it means when they are looking at accepting private funding for the first time. We have three fantastic panelists today. I'm going to let them introduce themselves in terms of their background, but we have to my left, we have Kimon Hatza. I want to make sure I get that, Kimon Hatza. We have in the middle Steve Carpenter, and we have Tom Penn with us. Before we get started, I wanted to make sure that we thank our sponsors. We have our longtime sponsors, MVM Associates. These are the folks that help you understand creative financing, tax credits, and things of that nature. We have our newest sponsor, Cesare Revis, an IP attorney firm. And then we have our host today, University Place Associates. And with that, I'm going to turn it over to our moderator, Kimon.
Thank you very much, Michelle. Good afternoon, everybody. My name is Kimon Hatza, and I'm a business attorney with GrowthCounsel here in Philadelphia. I've been practicing now for quite some time, but the GrowthCounsel firm consists of me and three of my partners. All four of us were together at a large law firm in Philadelphia a number of years ago. We've, as a good friend of mine says, put the band back together in recent years. We do business transactional work, all kinds of transactions from soup to nuts, including the kind we're talking about here today, financing transactions for early stage companies. With that, I'll turn it over to my co-panelist, Steve.
Sure. Good afternoon. So, I'm Steve Carpenter. I'm with Life Sciences Greenhouse of Central Pennsylvania, based in Harrisburg. The LSGPA invests up to $2 million in promising life sciences companies in Central Pennsylvania. We're a sister organization to BioAdvance, which services the Philadelphia area. I also teach entrepreneurial finance to MBA students at Penn State in University Park. And turn it over to Tom.
Thanks. Well, I'm Tom Penn. I'm a partner in a fund in Philadelphia, MVP Capital Partners. That's kind of my day job. My non-day job is I'm an active angel investor with Robinhood Ventures in Philadelphia, Mid-Atlantic BioAngels in New York, and I'm also one of the board members at the Life Science Greenhouse in Central PA.
Okay, well, we're going to talk about term sheets, and I'm going to start with telling you a little bit about term sheets from the legal perspective, and then Steve and Tom are also going to address other issues relating to term sheets. So first off, what is a term sheet? A term sheet is basically a non-binding agreement between the company and its investor, which sets forth the basic deal terms with the investor. Typically, we're talking now primarily here today about angel investments. You're past your friends and family round, and you're looking for additional financing from an angel investor. And those financings, can cover a broad range. I've seen them as small as $100,000, up as high as $1.5 million. Typically, I see them at $500,000 to $1,250,000 range. But again, as I said, they can be much larger or smaller than that. What does the term sheet cover? Well, it's going to identify the parties, obviously, and if there's a party that's an entity, it's going to identify its jurisdiction of formation. It will identify the amount of money that's being invested, the type of security that's going to be the vehicle for that investment. The vehicle of choice these days, at least on the East Coast, is a convertible note. The financing amount I mentioned, the interest rate of the note, the maturity date for the note, and importantly, the conversion feature of that note. What will trigger an automatic conversion of that note to equity in the company, as well as are there optional conversion features for the note. Let me focus on that for a second. When I talk about an automatic triggering event, typically a convertible note contemplates that it will convert to equity in a company in a future financing round. It is typically defined as a qualified financing. Now, qualified financing is not a specific amount of money generally. It's negotiated contractually and identified in the convertible note itself. It's not uncommon to see, an amount like $1 million being the qualified financing amount. And what happens is, when there's a subsequent financing, qualified financing, the note will automatically convert to the type of security that's issued in that subsequent financing. So why do people choose to use debt as an instrument, a convertible note, as opposed to equity? Because it's faster and less expensive. There are fewer issues to deal with a convertible note. If you're issuing equity at the outset, you have to deal with a whole host of issues that will be dealt with by the subsequent investor in the qualified financing round, perhaps an institutional investor at that point.
And valuation has a big part of that too, right?
Yes.
Yes.
So and again, probably it's a big issue in terms of an attorney drafting and helping to negotiate, but the actual setting of the value is something that would be by somebody who far better capable at doing that than I am. So the kinds of things that you guys will look at. So what happens if a qualified financing doesn't occur? Well, there may be options for the note holder to convert if there is an interim financing that maybe doesn't rise to the level of a qualified financing, but the note holder decides that they may want to convert in connection with one of those financings. That can happen. Or maybe nothing happens and the note matures. Now, I suppose they could ask for their capital plus their accrued interest back, but if you've had no financings up to that point, it's highly unlikely that you're going to be able to repay the note. Most angel investors are wealthy individuals. They're sophisticated enough to know this can happen. They are taking the risk when they enter into it. And more times than not, I've been able to negotiate an extension of that note. I don't know what your experiences are.
Very common.
Yeah. So they're not really interested in getting their money plus interest back.
Right.
They're interested in something more, so they're hoping that you're going to be able to meet that qualified financing threshold at some point. I did mention earlier that these agreements are non-binding. They're non-binding until definitive deal documents are prepared and signed by the parties. But occasionally there are provisions in these agreements that are binding. The two provisions that I see most commonly as binding provisions in term sheets are exclusivity provisions or no-shop provisions. What that means is the investor, particularly if the investor is investing a fair amount of money, an angel investor who's investing a substantial amount of money is going to probably want to do a substantial amount of due diligence on the company. And they're going to need some time for that diligence, and that diligence is going to cost money in attorney's time and other resources for the company. So they want to make sure that while they're doing their diligence, you don't pull the rug out from under them and enter into an investment arrangement with another investor. So that exclusivity is a period of time where they get to take a hard look at your company without you negotiating with any other potential investors. From the company standpoint, you're going to want to probably keep that period fairly tight. 30 days or less if you can negotiate it. The reason being is you want to keep the investor focused. You want them to be working expeditiously and in good faith towards either deciding to move forward with the transaction or not. And so a tight time frame is best for that kind of thing. Obviously, if they're working expeditiously and in good faith and they run out of time, you're going to grant an extension of some period of time. But the idea from the company standpoint is to try to keep that exclusivity period tight. It becomes even more of a factor if you're a hot company and there are a lot of investors out there looking at you. You don't want to be, if somebody's not going to move forward with you, you want to have the opportunity to talk to other people who are interested. Is that your experience, guys?
Very much.
Sure. The other provision that is potentially in the agreement and is frequently binding, if it is a confidentiality provision. Now, sometimes many of these term sheets have a provision that just says neither party will talk about the fact that they're involved in negotiations with each other. But I'm not talking about that kind of confidentiality. If you're a startup company and you're in the life sciences space, as I'm sure many of you who are listening are, you have intellectual property, you have other things that are of a confidential nature that relate to your company. So when people are coming in and doing due diligence on your company, you want to make sure that they're looking at that information solely for the purpose of evaluating whether or not they're going to invest in your company and for no other purpose. And you're going to make sure that if they decide not to move forward and they leave, they can't take information that they've gleaned during the due diligence process and utilize it for their own benefit or for the benefit of a third party when they leave. So you can either build that kind of fulsome confidentiality provision into the term sheet itself, or alternatively, you can cross-refer to a non-disclosure agreement or a confidentiality agreement that you will execute simultaneously with your term sheet and before any due diligence begins to make sure that you're protected. So those two terms are probably the only two terms that I see. Do you guys see anything else that's binding in term sheets?
No, I think that's
No,
pretty well
not
covers it.
typically. Let me say the NDA part, the confidentiality agreement, money sources, particularly organized money sources, hate NDAs. So, and there's a reason for that. Now, we end up signing them when we get pretty far down the road, like at the term sheet stage. Or there's one actually with Robinhood now that I'm going to sign because we want to move forward and I don't have any choice, honestly. But the thing about it is, the reason it's important and the reason not to expect people to sign them is because we never have any idea what we're going to look at where we already have something in our files. I mean, we might have seen your genius idea, and it might be in our files, or we might be talking to somebody else that's doing something really similar. So we're very cautious about signing NDAs. I understand why you want them on the other side, but it's a big risk on our side.
And there's also professional understanding in the venture field that they do not share information outside just to maintain their own reputation. But they really want to avoid the legal traps of signing an NDA if they can. So the way I see it.
I mean, if we had a live audience, people might throw stuff on what I'm going to say next. But I mean, really, you know, it's a huge deal if we're taking the risk of looking for what's in our file or what's in the file. And I haven't seen that violated ever, and I've been doing this a long time. Now, I'm not saying it hasn't ever been violated, but I haven't seen it.
Okay. So there are many, many other kinds of provisions that could get negotiated into a term sheet, particularly if the security involved was an equity security as opposed to a debt security. You're going to see a whole lot of things. I mean, from the investor's perspective with a convertible note, they're kind of kicking the can down the road a little bit or punting. They know that when that qualified financing comes, the institutional investor is going to be negotiating all of those really difficult terms in connection with that financing, and they're going to go along for the ride when their note converts into that security. So they really don't need to do it now, which is what makes the convertible note such a nice vehicle for this stage of an investment. But among the things, I'll just run down a list of things that you might see in term sheets where, with an institutional investor down the road. There's sometimes discussions of pre and post money valuation. We can talk about that a little bit later in the show. There are often investor incentives that the investor tries to negotiate, discounts, warrants, other things that are sort of incentives and sweeteners for their deal, options. You'll often see a capitalization table, both pre and post capitalization, on a fully diluted basis, which shows what the true ownership is of the company both before and after. The investor will probably try to negotiate liquidation preferences if the company's liquidated, or if it's sold, distribution preferences of sorts where they get their money first before people participate generally. They may seek preferential dividends, voting rights, seats on the board, D&O insurance, discussions of conversion rights, anti-dilution protections. Let's stop on that for a second. Preemptive rights. Often investors want to protect their percentage ownership interest in a company. So they negotiate for preemptive rights, which allows them in subsequent financings to participate on a pro rata basis in the securities that are being offered so they can maintain their percentage ownership interest in the company. That's a type of anti-dilution protection. There are other protective provisions, sometimes negative covenants or veto rights, where they have the power to stop the company from doing things, or at least be in the conversation if the company's trying to do something that may adversely affect their investment interest. Registration rights, information rights, and drag-along rights. That's a term that people might hear from time to time. What does that mean? If you go through several rounds of institutional investments, you may have institutional investors owning the bulk of the company at that point. Somebody may approach them and want to buy the company. If they've negotiated drag-along rights for themselves and they like the price that's been offered, they can accept that price and cause all the other shareholders of the company to also sell. That's dragging them along. That's what a drag-along right is. So that's another protection that might be negotiated in either a more substantial investment or in a future institutional round. And I'm going to stop there. Turn it over to Steve to talk a little. Did you want to?
Yeah, maybe to build on that just a little bit. Just wondering if maybe just so the audience understands the difference. You talked about the difference in complexity between convertible notes and equity financings, but it really affects both cost and time to getting to a closing. I don't know if you wanted to talk a little bit. Well, I guess my experience is typically convertible notes can be done very quickly. You always want to engage an attorney to make sure it's documented properly, but it's a generally simple, relatively simple document. And we've oftentimes seen one of the challenges we get into if we're investing later on is that convertible notes sometimes are I'll say evolve over time within a company. It's not unusual for us to look to put a convertible note in a company and they already have 2 or 3 other versions of notes, which gets pretty challenging. So you ideally want to try to have one somewhat standard format for your convertible notes that makes it easier for others to get comfortable with. But from a cost standpoint, typically convertible notes can be executed for, I'll say, thousands of dollars if you can keep it relatively simple. But an equity financing round typically involves tens of thousands of dollars, is my experience. Is that fair assessment?
No, that's true. The other thing that I think is really important is use care and make sure your attorney's experienced.
Right.
In this particular kind of transaction. It's very important. It's a lot better than it used to be, but you used to get the brother-in-law, who was a divorce attorney.
Right. You know what? There has to be a good attorney on both sides.
I agree with that.
If you don't have it on both sides,
Totally.
everybody's not rowing in the same direction, and that is really, really difficult. But when you have 2 experienced people, it goes a lot more smoothly. I absolutely agree with that.
Yeah, and I would also say that based on the level of complexity, you want to get an even higher level attorney involved typically. If it's a very simple note, maybe let's say a relatively young attorney at a lower rate might be okay, but as you get into complex terms and instruments, you really need someone with a lot of experience, and you're going to have to pay several $100s an hour for that type of resource in most areas.
Okay.
Great.
Why don't you go?
Sure. So basically, I was going to talk about what point in time do life science companies become eligible for funding, and so I would say really there are 3 fundamental criteria. The first criteria, a company has to be formed. If you basically are operating a sole proprietorship, there's really no mechanism for an outside investor to invest in that. So you would, at a minimum, would have to be formed as an LLC. Realistically, though, most investors want to see you structured as a C corp, or at least be able to convert to a C corp relatively quickly as part of the closing process. We've really seen the gamut: LLCs, S corps, et cetera. But it becomes basically a part of our closing process is an agreement to convert to a C corp.
Well, just on that point,
Sure.
I know that what we do typically in the LLC operating agreement for anybody that's an LLC is we make sure we build in a provision that discusses specifically the conversion to a C Corp
Great.
in the event of an investment.
Great.
So that feature is typically there.
It's
with
really
some of the documents
important.
that we do.
Really
Yeah,
important.
and you just underscored the importance of having the right attorney involved, even on the early stages when you're even forming an LLC.
Sure.
So that's great. So the other point, really, the other second criteria I look at is the company really has to be open to accepting outside investment. We run into an awful lot of people that have a great science, great business idea, but they've never gotten comfortable with the idea that they're really going to have to establish a partnership with someone on the outside. They really want to have total control over it. And if you're that type of person, and you can drive your business idea to success, have at it, so to speak. Glad to see that kind of business get established, but that's very rare. Most people don't have the kind of money it takes, especially in the life science field, to bring a company from idea all the way to success. That may happen, I'll say much more commonly in the retail sector or maybe in the IT sector, but in life sciences, it typically takes millions of dollars to bring a company forward. And so a founder really needs to get comfortable with the idea that people from the outside who've been working in that field for decades can be incredibly helpful, especially if it's your first business startup. Putting together, getting the right investor that you can truly establish a great relationship with, that can provide that initial funding is really just a huge benefit, and they can really help coach you through that process. Again, if you've got the right match, so to speak. But at the end of the day, you're giving up some ownership, and once you take other people's money, you really have to accept the fact that people have expectations relative to that, and there's a process really to manage that expectation.
Just touching on
Sure.
on the point that you made about the life sciences industry by comparison to others.
Right.
I represent a lot of companies in the technology space, and certainly software companies, from idea to commercialization might be 2 or 3 years, as an
Right.
example. For life sciences companies, that process can be 7 to 10 years.
Exactly. Right.
Used to be venture capital was interested in investing in life sciences companies, at an earlier stage, as they started to realize just how long that process is from idea to commercialization and going through clinical trials and all that stuff, and all the money that gets burned up when a company is not typically generating any income whatsoever.
Right.
It's a really long process, and it's difficult to manage and get through. So, lots of times there's really, really bright people out there, scientists, people that used to work for pharmaceutical companies or whatever, that now have ideas and they've built a startup company around it. But you really do need somebody with business expertise that knows how to manage that kind of a process. It is really, really difficult, and particularly in that industry.
Sure.
Let me say, early on in the life cycle of life science companies, when they were venture capitalists were first getting interested in investing in them, back with Genentech and companies like that, there were people who basically said, wow, our funds are 10 years long and this is going to take 15 years to get to market. What are we going to do? And basically everybody says, well, we've got 10 years to figure it out. Let's go. we'll have to, and that's what happened. I mean, people said, too bad, we're going to get there to the 10 years and then we'll figure it out. And the funds got extended and it just takes longer.
Right. Well, there's clearly a major difference.
Yeah,
in the
absolutely.
industry.
There's no question.
Yeah.
Sorry to interrupt you, but we
Sure.
have one question from the audience, and that is, why is it important to convert to a C Corp as your company matures?
I'll let you guys talk about that.
Well, I've got one reason is these days your company may be a qualified small business corporation and there's a huge tax difference between being a qualified company and anything else, if you qualify. You think?
I don't know, maybe.
I think it's a pretty big deal.
Yeah, I'm not an expert on the subject, but I would say one of the biggest reasons for being a C Corp is essentially allowing for equity ownership. There's limitations relative to S Corps. I don't know about LLCs, but definitely C Corp. C Corps are the structure that publicly traded companies utilize. So setting your company up to be a publicly traded company someday, through an IPO,
Right.
gives great comfort to investors. There's no further transitions to go through. It's basically a stepping stone to either an IPO or an acquisition.
Right.
It's not. I wouldn't say it's absolutely paramount, but if you want to have other investors participate and get new investors comfortable, that's what they get comfortable with, is C Corp.
Yeah,
Well,
that's-
they're also not pass-through entities.
That's
So
right.
when you
That's
set
right.
up the original company, you'll set it up so you have tax benefits for the original owners, but those benefits get to be an enormous pain in the rear going forward.
Yeah.
Well, they do, right?
They do.
Because you end up having to do a lot more paperwork and a lot more filing, and tax time gets to be a nightmare.
Right.
And
No
so a
question.
lot of it's just logistics.
And there's also, what, as I remember, like net operating loss carryovers from prior
Yeah,
years as a
that's
C
true.
Corp. So a C Corp has that benefit.
Right.
As if you accumulate 3 years of substantial losses, and then all of a sudden you swing to a profit, until those 3 years of losses have been basically absorbed by net income, you don't have to pay taxes on that as an entity. So there's significant benefit that way.
From the legal perspective, it's really been pretty much what you just said. It's a comfort level kind of thing. People know what corporations are. They know what they do. They are the vehicle of choice typically on stock exchanges and so forth. So they've been using those kinds of instruments for years and securities for years. So I just think it's all in all, it makes it easier
Right.
in terms of working with investors and things down the road.
Yeah, and my understanding, the cost of converting is really not that expensive, relative to attracting investors. It's relatively quick and relatively inexpensive.
Yeah.
And one thing, just kind of get off the list of concerns that an investor might have.
Right. Okay.
So
If you want the money,
Yeah. Right, exactly. Yeah, and that's the other part of this whole process, is you realize early on that the investors really have great leverage through that, and we'll talk about negotiations later on, but you have to recognize the fact the investors have tremendous leverage because they're the ones that have the funding. Unless you've got other sources of funding that are, quote unquote, competing with the prospective investor, you really end up having to essentially kind of lean towards what they're proposing with some minor pushback. Is very typical. So, but then the only other thing I just want to talk about was to recognize that companies. The third element I look at it is you really have to find companies. Your company has to be something that investors are truly excited about investing in. It's a pretty I'll say kind of daunting task to find the right investor. It's oftentimes the kind of the rule of thumb in venture capital field is one out of 100 companies that a venture capital firm sees actually gets funded. Again, working at Life Sciences Greenhouse, our ratio is more about 1 to 10. Ben Franklin, I think, is better than that. But as you go up the scale in terms of the amount of money you're attracting, the level of scrutiny gets much higher. The investors are really looking for several key aspects. They want to see that you really have great technology, well protected with intellectual property. You've got a really great market opportunity that's very large, that your company can grow and capture a really significant amount of revenue. If your company can't generate tens of millions of dollars of revenue after let's say 5 years is kind of the typical rule of thumb, then it's likely not going to attract much in the way of investors because they can't figure out a reasonable rate of return for their money. So understanding that market opportunity and how you can capture that effectively and convince investors of that is really critical. And the other one I would really like to stress is the management team itself. The investors really have to get comfortable with the team. Things like I'll say how you interact with the investor. Treating them professionally, responding rapidly when there's requests for information. Providing information in a clear, concise way that investors can easily absorb and evaluate. Being able to demonstrate to an investor that you're coachable, you're willing to listen to their perspective and maybe change your strategy somewhat, maybe based on your hiring plan or your go-to-market strategy or those kind of things. But if you basically demonstrate to an investor that it's basically your way or no way, investors are typically going to walk away from something like that. So anyway, so that's I think a big part of it. And then also just recognize, as talked about the terms, and when you first see a term sheet, you have to realize that that these investors are investing extremely early in a business idea at the stage of, like, say, our organization, BioAdvance, Ben Franklin, or angel investors, and they're typically looking for about a 10x return on their investment. That sounds like really harsh in terms of expectations. You obviously wouldn't if you went to a bank to borrow money, they're not looking for a 10x return. But in this environment, the failure rate is so high. Investors that may have, let's say, 10 or more companies in their portfolio, the general model is that most of those are going to fail, and they recognize that. So that's a lot of money lost, but they're looking for those one or two successes that will really kind of carry their portfolio, so to speak, and hopefully give a 10x return from those. So just recognize that those investors are really looking at their overall potential return relative to the risk, and are really coming at it from that perspective. So
just touching on risk a second and how it maybe ties into the due diligence process. Obviously, the higher the risk, the more expensive the money that's being invested. When the diligence process starts, the investor might have one expectation, and then in the course of that diligence, uncovers some things that makes them a little bit less comfortable. They may still like the deal, but they may not like the deal at the price that they were originally discussing with the owner of the company, because there's a risk that they were not aware of.
Right.
So higher risk, higher cost of money.
Right. Exactly. I think that covers it. I could talk about due diligence if you want. That would be helpful.
Sure.
Okay.
We all love due diligence.
Yeah.
So due diligence is a term that's I say used quite a bit in the investment field. Banks use that term frequently, but in the world of private investment, due diligence is in most cases associated both. I'll say before the term sheet is I'll say negotiated and agreed upon, as well as after. We touched on a little bit before about what investors are looking for prior to a term sheet being agreed upon, and really that's really just getting them to the point where they're comfortable at least coming up with terms for an investment. But before they actually commit and generate final documents, they do a much more formal due diligence. They look deeper into the intellectual property. They will do maybe a deeper analysis of the market opportunity. They'll do background checks on the management team, and they will also really review in great detail the corporate documents, everything from financial statements over a several-year period or since inception. If there's been a board established for the company, they would look through board minutes, any of the corporate actions that have been taken, and really try to get themselves comfortable with the company going forward. And if they uncover issues like that, as Kimon alluded to, then usually what happens, those become essentially requirements to be addressed prior to closing. No different than if you're buying a house, you would identify issues that need to be addressed before you would complete the deal. So those are the kind of things that are really done to really try to protect the investor and also try to set the company up for future success.
Yeah.
So
just on that point for a second, and one of the things that I try to impress upon early stage clients is the need to address the kind of corporate niceties that you need to do. Have an agenda for your board meeting. Have a rough draft of the minutes of the meeting go around to everybody afterwards. Then prepare for the minutes and put them in your corporate minutes book.
Right.
Do things the right way.
Yeah.
From the standpoint of a lawyer that comes in and looks at companies, I've seen companies, and this maybe comes up in diligence more in an M&A kind of transaction, but I've seen where I'm representing a buyer and we look at a company, and the company was formed in 1978 and has never had a meeting.
Right.
Their minutes book is empty.
Right.
They don't have standard forms of contracts with their customers. You don't know whether those contracts with customers are assignable or not. There's a lot of issues that can come up in diligence, and you want to look like you're a professional operation. Mm-hmm. You want people to come in and have a comfort level with how it looks. So you got to do things the right way. You really do.
Right.
Tom?
Okay, well, let me talk a little about who can extend term sheets. First, my personal view is every company who's out there looking for money should have an idea of what the term sheet is they would like to get. And in spite of the fact it might seem like a lot of work, it's not tons and tons of work to come up with your key terms and put them down in a term sheet. Now, having said all that, a lot of times the money side, which includes me, we hate it when there's a term sheet out there because we'd like to be the ones that put the term sheet out and have the discussion. We'd like to be the lead on that, but it's useful to have it yourself and have an idea what you want. And it's particularly true if you're anywhere near being that person that doesn't really want to take money from somebody else, then you better be as precise as you can. Or, go work with the NIH or SBIR grants or in your garage or wherever, because that's still possible to do. The probability of you kind of escaping the garage is pretty low, though, I would say. I mean, guys who start in the garage, except for Hewlett and Packard and a few other folks, if you're not out of that garage pretty quickly, you might be in there forever, and that may be the right business for you. That may be what what you're set up to do, and might be exactly what you and your family need. But you don't need our money if you got that case. So, term sheets. So, for me, the best thing about a term sheet is it enables you to cut out all the negotiations and stuff that you would go through otherwise. So I think the term sheet's useful because what do you think the average length of a term sheet is these days? 2 pages, 3 pages? I mean,
particularly for this stage. If you're talking about an angel stage investment, it's pretty short.
Very early.
At least for convertible debt.
It's very early.
For convertible debt, it's probably very short.
Right.
So you can get through a lot of these. You can get through a lot of issues in your term sheet. Valuation is one of them. I know we have valuation discussion coming up later, but I mean, valuation is important. What the nature of the security is. All these other items that have been mentioned. They're all in there. It's great. And the beauty of it is, if we see somebody we like as a company we think we might want to invest in, it's better to, in my view, go out and say, look, this is a draft term sheet, and this is what we're talking about. Do you think we can get to a deal based on this term sheet? And if they say, hell no, we listen certainly, but we usually those don't happen. Nobody's wasted months and months, particularly if you're the company that's looking at 100 sources or the sources that are looking at 100 companies. Either way,
I can pause here for a moment because something we talk about at this stage of investment relates to one of the audience questions, which is how do you folks define early stage? So how would a term sheet that's presented to angels, for example, or a seed stage investor maybe differ from one that's presented to a later stage company?
That's a great question.
Well, I'll talk about it first from the legal perspective, and then you guys can fill in. I mentioned some of this early on, but the fact that convertible debt is the vehicle of choice, let's say for an early stage investment, like an angel investment, you've completed your friends and family round, and now you're looking for additional money, but you're not yet positioned for an institutional type investment, a Series A round or what have you. So that the convertible notes are easier and faster. The term sheet is going to be shorter. There's going to be fewer items covered because most of those items, most of the really, really difficult items that are going to get negotiated are going to get negotiated at the institutional round. And all of those things I listed when I spoke initially of the kinds of things that could show up in a term sheet in an institutional round when you're talking about preferred stock or something like that as opposed to convertible debt. So that's from a legal standpoint of what the term sheet looks like. That's would be my biggest distinction, I guess, between early stage and later stage.
Right. I think from a stage of company perspective, I'd say relatively recently there's been a term used called seed stage investments or a seed round. But in most cases, I'll say people tend to look at early stage company as one that's recently been formed, clearly pre-revenue, and really is basically doing their first round of significant financing, either as convertible debt or as equity, and then there's different levels of, let's say like Series B, Series C, et cetera, are oftentimes referred to as later stage investment rounds. But early stage typically just is something that's typically maybe under $2 million, and it represents oftentimes the very first round of funding of consequence that companies are going for. So is that?
Right, yeah, that's true. Yeah. I think there's a lot of, to me, there's a shocking number of seed investment opportunities out there that are only $200,000 to $500,000.
Exactly, right.
Even as an angel investor, I'm shocked, really, that there's that many that are there. But it's because you think, what can you get done for 200 or 500? And the answer is a lot of times a lot. And so you can get to the point where you're still early stage, but you can maybe raise that price
next
round.
Or,
right.
Very good.
I'm sorry, were you done with what you were saying, or did you have more?
I'm still in there. I think that I think the sooner a term sheet is out there, assuming people are interested, the better, really. And in some ways, I don't care who offers it up, but it's important to get to the terms, figure out whether you can live with the terms and whether there's a potential deal there, because otherwise, why waste your time, which is what you don't have any of anyway.
Right. I think, see if I have the same perspective you did. One of the things that comes up oftentimes, Tom and I have been on boards of startup companies for many years, is should the company basically put together their own term sheet, or just go out and just talk to investors and let the market basically drive the term sheet? I'd say in many cases, I don't even know what the ratio is, but in many cases, companies feel more comfortable just at least trying to draft the term sheet, but willing to walk away from it if they run into a major investor that's willing to cover a significant portion of the financing. But at least the process of putting together a term sheet by the company is a very good exercise to help to understand the different aspects of it. And then when an investor does come to you, at least you have an understanding of the terminology and what the game is, so to speak. So.
Right. So in one sense, I mean, determining whether you have fit between the investors and the company is part of what the term sheet can do for you, particularly if you're willing to get it out there early and have it as part of the conversations. The other thing, there's been a question about angel investors and term sheets. I can speak to Robinhood and Mid-Atlantic Bio. I mean, both of those organizations are pretty similar, I think. We would all love to be the guys that write the term sheets. There's just no question, because we feel like it gives us better control, which is probably an illusion. But in any event, it gets us out there and our thoughts out there, and they're on the table, and we can negotiate from there. So we would like to do that. We can't always, and part of it is because a lot of times we're not the biggest part of a round, or you're right, we're part of a syndicate where somebody else has got a term sheet. So I guess company may have to accept a term sheet, but a lot of times, poor us, the other guys who are in the syndicate, may have to accept a term sheet with terms we wouldn't necessarily agree with either. And that's just part of the system. But I do think it's a lot better than trying to go write the documents where, with all due respect to the documents, they can be long and tough to read and really not worth doing if you're not going to get to a deal.
Exactly.
Well, on that point, and this is a selfish thing for me, but a term sheet is really helpful to the lawyers. It really is.
True.
It's the roadmap, from which your documents are prepared. Nothing is worse for a lawyer, and frankly, nothing's worse for a client if your lawyer is drafting to a moving target. If you don't have a set deal and the terms are changing, that's inefficient. It's expensive. It's like terrible all the way around. So a term sheet at least gives you that roadmap, so you know what you're drafting to.
Right. It's true.
One of the questions from the audience is, are there particular terms to avoid when in negotiations or discussions with an academic partner?
Say that again. I was with you to the last 6 months.
A specific question here. So the question is terms in negotiations with academic partners.
Would that be like an institution, like an academic institution, you think, Michelle?
There are terms around licensing with university partners to avoid.
Great question. Yes. So one of the things we come across that a lot, and I'd say institutions like I'll say Penn State, for instance, has evolved over the years in terms of how much they really how they structure their licensing terms. There's a lot of different, I'll say, moving parts to those. I'd say the biggest one that most investors really hate is if there's a substantial, I'll say, upfront payment based on closing the licensing deal or within 12 to 24 months after agreeing to the licensing deal. It basically just pulls money out of the company when that money is really expensive and really can be used for a lot of other things. And oftentimes the license can be structured as a royalty is one scenario. I think one of the ones that probably gives us most comfort is if it's structured as basically just a percentage of equity. And then the only other significant to that that's a really critical variable is whether it's dilutive or non-dilutive. Typically, academic institutions will try to structure it so that essentially it's non-dilutive. So if they license technology and they have 3% of the company, no matter how far the company goes, they still own 3%, which is a great deal for the university. Most of the time, investors try to encourage companies to put in a cap that it might be non-dilutive up to a point of, say, $5 million of invested capital, and then it's dilutive after that, just like any other investor. So I would say that's probably one of the most critical ones is understanding that and avoiding those large payment fees, if at all possible. Small ones to cover some of the intellectual property costs you can understand, but otherwise, big money payments out is really a tough thing for investors.
Yeah.
So.
Right. I mean, it's not strictly a venture term, but when you're negotiating with the universities, you've got to be really careful about your terms. So if you're non-exclusive, chances are you cannot defend the patent, which means it's essentially worthless.
Right.
The license, that is, essentially worthless. The patent may be worth a lot.
Right.
So you've got a lot of very specific issues around intellectual property and licensing intellectual property and patents either in process or already issued. You got to pay attention to those. So you need a really good IP person around with you.
Yeah, when you say IP person, you mean IP attorney, right? In most cases?
Yeah.
Yes.
Yeah.
Yeah, and I would say just build on that too. I think the exclusivity is really critical. So it needs to be exclusive for your interested field of use. Doesn't mean it needs to be exclusive for everything, but you want to make sure it's at least exclusive for your field of use. That's very helpful and very important.
And you need to be careful. You need to make sure that they're protecting the geography you want protected.
Right.
So if Europe's important, get it.
Yeah,
The U.S. is important,
right.
get it.
Yeah,
China's important,
exactly.
get it.
Exactly. Yeah, the other thing I've seen too, just from a timing standpoint, I think sometimes founders struggle with whether I go ahead and finalize the licensing agreement before I have investment money or try to do it after. I think getting the investors, early stage investors, advice on the terms. Most investors, if they're doing due diligence, really want to get involved in that process if they can. If they can influence what that licensing term looks like as part of their funding commitment, that's I think ideal if it can work out that way. It doesn't always, but that's ideal if it can happen that way.
That's true, and there's a really loose connection between time to get those agreements done and financing. In other words, they take forever. I think many groups, including the ones I'm in, we've gotten to the point now where we are not going to proceed probably even to a term sheet unless and until you've got your license done. Not maybe done, maybe partly done, because, with all the respect to the university people, all of a sudden it gets to be, July 1st and they're in Europe for 3 months. And it's pretty hard to negotiate with. Okay, all you university people, chuck that stuff right at the screen right now. But, there's a lot of disappearing that goes on in university intellectual property departments and other places.
It is a very slow process.
It's very slow. It's already slow.
Right.
It's hard to push.
Right.
And we have other deals to look at and don't have time to waste.
Right.
So we'll be there when you're done, but it's important to try to get done in some reasonable, timely fashion.
On the plus side for universities, I think they're getting much more sophisticated.
Way better.
In terms of tech transfer and how they're commercializing ideas that are developed within universities, for example. They're all getting a lot better. And it used to be a really, really horrible negotiation from a legal standpoint. So I've seen vast improvement over the years.
Oh, way better.
Yeah.
Way better.
So another question from the audience not related to the one we just covered, and that is, do you have any best practices with respect to initial valuation?
Okay, I'll take a shot at this. You know,
Don't value it.
a long time.
Don't value it.
No. You're going to make me talk about safes?
No,
We're not talking about safes.
Go ahead.
I'll get to that.
Right, exactly. Look, here's the point. Point about valuation, first off, is there are comparables lots of times, and you should find out what other people got if you can. It might be hard to do, but you can get some kind of an idea from that. The main objective you have to remember is to get greed to overwhelm fear, and that's all about how much money people can make usually. I still think there's a lot of, and there are, people have sophisticated models, all kinds of discounting, all kinds of factors, and they try to get to a valuation that's very precise. All that stuff's okay, I don't have any problem with it, but still, I think most of the valuation that gets done, at least to get to the term sheet, is, okay, they want $10,000, they want pre-money to be 10 million, whatever. Did I say 10 million? They want 10 million bucks.
Right.
Pre-money, 10 million, 20 million post-money. They want 10 times their money back. So you got to sell this thing for 200 million if you don't raise any more money, you know? Just, it's simple math, really. And that's, I mean, just do some, you know, really just that simple. As I don't think it does you any real good to do the sophisticated models. I mean, the simple stuff is just pretty much where I think most people are.
Yeah, I would also say, you know, people can do like fancy discounted cash flows. I would say most financial projections that we see are really not very accurate or are never accurate. Better way of saying it. So doing a discounted cash flow on a financial model is really kind of pointless. You have to put a very high discount rate on it in the venture space, which isn't a great fit. I think the better, to Tom's point, I think the better assessment is really looking at companies similar to you that raise money at the same stage. So if a medical device company that has a product developed, but it's done animal testing, but no more, and it's in a certain space, you could say, okay, that might be worth $2 or $3 million. If it's gone through clinical trials and it's basically on the verge of going to market, just waiting for regulatory approval, you know, it might be 30 million. But investors see a lot of deals, and so they typically kind of gauge the value of your business relative to the other deals they see, as opposed to something else.
So give suggestions for young companies. How could they get access to similar kinds of information about what other deals have been valued at?
Good question. Wow.
Well, if they got good counsel,
That's-
because maybe they can get, you know, to the extent they've already hired lawyers and accountants and that they're really plugged into the community, you can get some idea there for sure.
Yeah, there are some databases that are very expensive. They can be, you know, tens of thousands of dollars. If you can find someone that has access to some of those venture databases, they can oftentimes give you a flavor for companies in your general space in terms of how much money they raised and what the pre-money value was. The information's, I'll say, not 100% accurate. I've looked at a couple databases, but they tend to be maybe 75, 80% accurate. So if you're really just trying to get a baseline, those databases can be very helpful. And I would say just try to use some network connections, maybe some prospective investors or some others, maybe the attorneys that could, or economic development organizations that may be able to give you that kind of support.
It's important to remember this is probably the most subjective part of the whole process, at least in my view. Pricing's hard. And at the end of the day, don't sign up for a price you don't believe in, you know, because you'll hate yourself later. It's better to stick around and work hard to get something you like. Maybe you raise less money. Maybe you put milestones in so that you get a valuation kick if you're successful with something important that has to happen along the way. There's other answers, but it's highly subjective and very emotional on the part of everybody.
Yeah, and I also say investors typically like to see in the early rounds that the founders don't try to carve out a really high valuation to start. You know, let the valuation grow over time. So just, you know, try to get comfortable with the fact that an early stage investor is going to invest at, you know, maybe $2 a share with the expectation that it can go to $3 or $4 a share for a following round. If the company is not progressing, and they have to raise money, and no one's going to invest unless they drop the price, that gets really messy quickly. So you want to try to avoid that if at all possible.
Okay, well, I was going to talk a little bit now about some common terms. You've heard probably thrown around in our discussion today, and you may have heard independently some of these terms. We did talk about convertible notes. Convertible debt is essentially a form of short-term debt that upon some sort of triggering event will convert into equity in a company, and usually that triggering event is a future financing of the company. You've heard us mention pre-money and post-money. What does that mean? It's really the pre-money valuation of the company and the post-investment valuation of the company. So in a really simple example, and you guys can look at this if it's overly simple, but if your company has an agreed upon pre-money valuation of $2 million and an investor puts in $1 million in cash, you're going to have a post-money valuation of $3 million. So it's that simple, and that's what it means.
If I can just add to that a little bit. The only other little caveat to that is if you have convertible debt in a company, using your example, you want to make sure that investors understand that a pre-money valuation does or does not include the convertible debt that's on the book. So typically we would encourage companies, in your example, to say we have a pre-money valuation of $3 million, including convertible debt, with $1 million new, gives us $4 million post. Is the best way to look at it in our perspective.
Okay. So. We did talk about qualified financings previously, and that's really a contractual agreement in your convertible note as to what the size of the future investment needs to be in order for your note to automatically convert into the equity issued in that future financing. Anti-dilution provisions, I referred to them earlier. I don't know if anybody else did, but we talked specifically about preemptive rights previously, and that's the ability of an investor to maintain its percentage ownership interest in a company by negotiating the ability, a preemptive right, to purchase its prorated portion of future financing rounds so that it can maintain that equity position. You may also hear the term ratchet, full ratchet, partial ratchet. That is an anti-dilutive protection for a down round, and what I mean by that is if an investor with a convertible note, let's say, purchased at a particular price and the valuation of the company has gone down, and the investor typically has a discounted conversion price over what the next round, which you would presume was going to be a higher round, would be. But now you've had a down round, and it turns out that your discounted price is higher than the current value of the company. If you negotiate as an investor a full ratchet provision, that means that you automatically, your conversion price will reduce to that now current value of the company, the lower value, and that's protection against what's known as a down round. Some folks have questions about regional differences in these kinds of transactions, and the one that I hear most often is the use of a different kind of security instead of a convertible note. The use of an instrument known as a SAFE stands for Simple Agreement for Future Equity. I do not know much about these instruments because I have not been involved in any transaction where they've been used. It has some features that are similar to a convertible note, but it doesn't have a maturity date. It doesn't have an interest rate. Sometimes people with convertible notes want to securitize that note, and that's a really difficult thing for an early stage company to do. None of those things are involved in a SAFE. There's only one term that's negotiated. It's a valuation cap. And that's pretty much what I know about it. It's an instrument that is used more frequently on the West Coast. We get a lot of inquiries from clients about the use of them, but it's really not an instrument in favor in this part of the country. I don't know what your experience is.
Well, I've only, on the angel side, I've been in a couple as part of groups. I know folks who have had sort of the worst possible experience, which is money goes in, the company fails, and the SAFE ends up holding nothing because they have no rights. They're treated as equity. in a liquidation scenario, and that means really they get nothing. And whereas if you had a convertible note, theoretically it would have some status, and you'd get at least something. So
You'd be an unsecured creditor in a bankruptcy, so you get pennies on it. You might get something.
You might get pennies. The other one you don't. So
From an investor's perspective, it's not ideal. From a company perspective,
you know, some people. Just to be fair, I mean, as much as I don't like them, there's a lot of people that like them. You know, and I don't get it. I don't get it. I think by and large, you're right. On the East Coast, people just don't get it. There's some of them, but not many.
A couple more questions from the audience? Yeah, so one is about, do you have a preferred exit strategy for these investors, or is there a preference, or what determines the exit strategy?
Talk to that one.
Yeah, I mean, we want to make more than we put in.
A lot more.
No, I think in our case, we definitely like cash deals. I think most folks are into getting cash, if that's what the question was. I don't know if that's how to interpret it, you know. But
Well, are you focused on a public offering? Are you focused on
well,
a sale
it's true,
of the
public
company?
offering. No, we have companies that go public. Problem is, if you end up owning a lot of that company that goes public, then you've got problems with selling your piece, and you know, I guess it's trickier. So I think, you know, really we tend to be looking for folks that want to come. And also, we do a fair amount of life science kinds of things. So there typically, you know, there's cash up front and then cash that follows on and maybe a royalty and all these different pieces that add up. But essentially, they're cash sales. You know, it's about the cash. And it's really about the cash, just in my case, my view anyway, because that's what's easiest for us to feed back to our limited partners, because we've got to give our limited partners a return so we can raise another fund. Or if you're angels, we've got to do it so we can keep the insanity going ourselves, you know.
And then we have another question about risk. The foundation of the question is, would you invest before FDA approval? And I think you.
Oh, sure.
Clearly.
For sure. If you could maybe talk a little bit more about the kinds of things that, what are milestones in terms of knocking out risk? Would be a good way to approach the question.
You want me? I'd do that.
Go for it.
Look, milestones can be anything depending on how exciting the company is. There's no question about that. But I mean, typically in the FDA, could be just as simple as animal testing or getting to a final formulation. We definitely, if we have a company that's governed by the FDA, we definitely get all over their development plans and what they have to do for the agency. Because one of our public company CEOs says, you know, basically they're omnipotent and they can do whatever they want, and that is absolutely no exaggeration about the FDA. They are omnipotent and they can do whatever they want. And that's not a criticism, it's just a fact. So, but I would say first animal studies, certainly first in human, there's a milestone where a lot of things can happen, particularly if it goes well. You know, there's a lot of times there where you can get bought out. Any of the phases, phase 1, phase 2 clinical trials, certainly after phase 3, then then you've either got to figure out how to market the product or how you monetize it. So yeah, anything related to a discrete step with the FDA.
Yeah, and just to build on that too, I deal pretty significantly with a medical device company we've invested in for quite a while, and they're also pursuing regulatory approval in Europe through a CE mark, and it's really interesting to see how the FDA's approval process and the European approval process kind of ebb and flow with levels of scrutiny. At one point in time, we thought the European regulatory process was going to be easier, but as we got into the trials, they basically tightened up their requirements. So and then the company ended up pursuing FDA. I'll say subsequent to it, and it went much quicker. So really, there's a lot of dynamics that go on through that process. But as Life Sciences Greenhouse and BioVance as well, I suspect, are very comfortable investing in the earliest of demonstration of the technology. And without getting into a lot of detail on it, there's just having some demonstration that the technology has promise is all we need to put money in, but we put a pretty small amount of money in the beginning. But it's clear that large investors want to see much more proof through significant animal data as well as first in human and hopefully beyond that. But I also, as we talk about regulatory approval, it's really important to have a regulatory strategist involved. Oftentimes it's an outside consultant that's dealt with the FDA before. They can be incredibly helpful at laying out a regulatory pathway and really helps the investors understand how much money is this really going to take to get to an exit. Without a good regulatory strategy, you're really working in the dark.
Yeah, your regulatory people, be prepared to spend big bucks for them, and
Right.
don't begrudge them a single dollar, because they are going to be what gets your company through to the end.
Yeah.
No question.
Right.
Any more? Okay, the only other thing I know that I wanted to cover, and was there something else that you were going to talk, negotiations or something like that, or are we, how much time do we have?
We're at 10 after, so maybe about 5 more minutes.
Okay, well, why don't I talk just a little bit about boards
That's a good
and
topic.
board
Oh, that's a
composition.
great topic.
Yeah.
And I'm interested in your view, because from a lawyer's standpoint, boards are, I'd rather have a smaller, nimble board than a larger, cumbersome board. When you need to do things quickly, you have to call, the meeting on Sunday night or, whatever, or get people on the phone. It's nice to have a smaller board, but you may not be able to control that. At an early stage, you got to have a board. You'll have a founder, maybe 2 on it. If you have an angel investor that puts a substantial amount of money in, they very well may ask for and want to be on the board. So you're likely going to have to do it. If they're not putting in very much money, then maybe not. An independent board member is important to have. Someone that's is a fixture or a player somehow in the industry that you're in, that has some gravitas and people recognize and know, helps lend credibility to your entity. As you start to go through institutional rounds, if you have a first, second, third, or however many, that board's going to get larger. At the smaller stage, you're 3 to 5, and I would, from a lawyer standpoint, I would go for 3. When you get to through those institutional rounds, maybe 5 to 7. At some point, the founders may get squeezed out of the board, or maybe there's only 1 left on the board, and you'll have your investors' seats, and then maybe several independent seats. In terms of your operations, I would suggest that you do things the right way. I said this earlier, but clearly with regard to your board, you want to have a good relationship with your board. You want to understand each other. Tap into their knowledge and advice. These are people that have experience. They will help guide you, and they'll help develop a strategy for the company. Meet regularly, quarterly. Prepare agendas before you meet. Do minutes afterwards. Do everything the right way, and stay in front of them. Try to meet in person if you can. I know that's not always possible. People are spread out, and meetings can be held by telephone, at least as long as everybody can hear each other and understand what everybody's saying. But it is not a bad thing to be in front of people and for people to get to know you and to have a comfort level with you.
Yeah, I just build on that quickly. So I'd say the board is really a critical part of a company as it matures, and the sooner you can establish one, the better. Kind of the typical, let's say, kind of starting board, maybe 3 to 5, but you clearly have to expect that almost 1 investor for every round of financing is almost going to end up needing one seat for the largest investor if they haven't already invested in the company. The independent directors are really critical. As you're looking at overall board composition, I try to encourage our CEOs to try to put the board together in a way that you've covered all the kind of fundamental aspects of the business. Someone that knows the industry extremely well, someone that knows financing really well, maybe someone who's basically had a company exit in that space before, or start a business in that space. But try to make sure you've got all your bases covered. If you as CEO are lacking in certain areas, make sure there's people on the board that can backstop you in that area, whether it's go-to-market strategies, et cetera. So, best I can do.
I agree with all of that.
Okay.
I don't really have anything to add, except I do like, at the beginning, the smaller the better.
Right.
I think that's it.
Any final words that you'd like to share? Any overarching comments from our panelists?
But just expect the unexpected, I guess.
Yeah.
As you go through the whole negotiation process, when you go from a term sheet to closing, depending on who your investor is, the only thing I would suggest is make sure you do some due diligence on the prospective investor as well as then doing it on you. You want to make sure it's a good partnership.
From a legal perspective, for people who are new to these kinds of transactions, the amount of paper that's involved, the documentation that's involved, is really extensive. People do not really anticipate the volume. Now, it's much less in a convertible note type of financing, but when you get into the institutional rounds, I mean, go online and look at the National Venture Capital Association documents to see just how extensive the documentation is. People are typically blown away by how much is really involved in the transaction. So don't be surprised. Take a look at those things and prepare yourself for what's in store.
Right, this is very important, but it won't be the most fun thing you do growing your company.
Right, there you go.
Well, thank you all very much. Thank you to our great panelists, Kimon and Hatza, who interrupted our road trip to come be with us today, Steve Carpenter, who faces a long drive back to State College, and Tom Penn, who I understand is battling a bit of a cold here.
Exactly.
So thanks for volunteering your time with us today. We really appreciate it. So on behalf of BioStrategy Partners and our sponsors, once again, MVM Associates, Cesare Reviz, and our hosts here, University Place Associates, thanks so much.
Thank you.
Thank you.
Thank you.